Welcome to Pennsylvania in Focus. I'm Anthony Hinnon, Pennsylvania reporter for the Center Square. Joining me today is the Center Square's Pennsylvania editor, Kristen Smith. Kristen, we have some movement on abortion law and abortion access in Pennsylvania, as we've seen a state Supreme Court ruling that you say sidestepped the question of access. What exactly is going on here?
This is a complex ruling, so I'm going to do my best to break it down. Back in 2019, 7 abortion providers sued the Department of Human Services, I want to say a state agency, sued because Medicaid for 3-4 decades has not covered abortions except in the case of rape, incest, or dangerous life-threatening complications for the mother. And these reproductive centers say that that's unfair, that's unconstitutional, and that's discriminatory against women based on sex alone. The law with the Medicaid exclusions was passed by the General Assembly back in 1982. The Supreme Court upheld the law in 1985, in part ruling that the state had a valid interest in protecting life since it, obviously tied into the future of the state's economy and, life here. So that was their reasoning back then. Then flash forward to Monday, I believe it was, the state Supreme Court came back on this decision with some interesting insight that does, as the headline of our story says, brush up against constitutional abortion access, but not quite in the way you would think. The majority opinion said that the lower court erred when it dismissed this case brought by the reproductive centers and that they need to go back and hear it, partially because the trial court should make the decision whether our Medicaid exclusion law is unconstitutional or not, because in their view, that exclusion law is discriminatory because it clearly favors birth over abortion, and the law should be neutral and should support women in whatever choice that they make, and that this law disproportionately hurts poor women because the cost of an abortion can be really excessive for them, and that it stresses reproductive centers who have to use time and resources to help them find ways to pay for the abortion. So that was the arguments that seemed to carry some merit with the justices. And so they kicked it back down to the Commonwealth Court to relitigate this. Now, what makes it complex is that even though five justices signed the majority opinion, that was all the ones that had ruled and were participated, 3 of them also wrote dissenting opinions saying that they disagreed in part with some of the justifications that the majority opinion used to remand the case back to Commonwealth Court. And one of the complaints was that the majority opinion very strongly suggests that there is a constitutional right to abortion in Pennsylvania. And the argument or the disagreement here is that this specific case is not about that. It's about the Medicaid exclusion policy and whether that's constitutional. But there was somewhat of a wide agreement that the case of constitutional access for abortion writ large is something that they expect that will come to them in the next few years.
So it's sort of a debate over how wide this case is touching on abortion law, but also it's basically keeping alive a case, and this will be still working through the courts. I mean, will this get settled within Pennsylvania, or do you think this is one of those cases that could just keep getting appealed and maybe become a federal ruling of some sort?
I think it's got a long way to go in Pennsylvania first. What seems to be happening in Pennsylvania, as has happened in other states, is that even if the court is not acting on the constitutional access question, the legislature is trying to put an end to that conversation, or to settle that conversation, I should say, not really put an end to it. 2 years ago, Pennsylvania tried to pursue a constitutional amendment that, if approved, would have reaffirmed that the state constitution does not provide a right to abortion. That constitutional amendment has to pass in 2 consecutive legislative sessions before it can end up on a ballot. That didn't happen. And now that the Democrats are in control of the House, they are adamant against bringing that up. They are more supportive of the Supreme Court handling this issue. There are other states that have dealt with this in a similar way. California, Michigan, and Vermont, in the years after the Roe v. Wade reversal, they approved constitutional amendments that protected abortion. Kansas, which was interesting because it was just weeks after this U.S. Supreme Court decision, they shot down a constitutional amendment that would have been similar to what Pennsylvanians would have voted on, which would have said, we don't have the right to abortion in our constitution. But in Kansas, voters said, we don't approve that. So that basically says that they want a constitutional right to abortion. So the likelihood, as long as the partisan split in the House and Senate remains the same, I don't think a constitutional amendment is going to find its way. Although Republicans' belief here is that the voters should choose. So that's where they're coming from on this argument. I think as long as the makeup stays the same, a lot of these court rulings are seen as paving the way for the ultimate constitutional access question.
Listeners can keep up with this story and more at thecentersquare.com. For Kristen Smith, this is Anthony Hinnon. Please subscribe, and thanks for listening.
Audible is a great way to gain access to an ever-growing selection of audiobooks. They've got what everyone's listening to, bestsellers, new releases, that story you've been waiting for. Follow the link in our show description to get 30 days of Audible free.